Utah has a clear and well-organized approach to lease termination that reflects the state's overall landlord-friendly posture. The governing law is found in the Utah Fit Premises Act, Utah Code Title 57, Chapter 22, along with the state's unlawful detainer statute in Title 78B, Chapter 6, Part 8. Together, these statutes give landlords a relatively efficient framework for ending tenancies when necessary. Let's start with the no-cause termination rules. For month-to-month tenancies, Utah requires either party to provide at least 15 days written notice before the end of the rental period. So if rent is due on the first of the month, and you want the tenancy to end on the last day of that month, the notice must be delivered by the 15th. This 15-day window is shorter than many states that require a full 30 days, giving Utah landlords more flexibility. For fixed-term leases, the lease expires at the end of the agreed term, without requiring additional notice, unless the lease says otherwise. If the tenant stays beyond the lease term and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the same 15-day notice requirement. For week-to-week tenancies, the notice period is 5 days before the end of the weekly rental period. Now let's get into termination for cause, and this is where Utah gives landlords some of the strongest tools in the country. For non-payment of rent, Utah allows the landlord to issue a 3-day notice to pay or vacate. If the tenant doesn't pay the full amount owed within 3 days, and that's 3 calendar days, not business days, the landlord can file an eviction action. Utah's 3-day window is among the shortest in the nation and gives landlords the ability to act quickly when rent isn't paid. For lease violations other than non-payment, Utah also uses a 3-day notice to comply or vacate. The landlord must identify the specific violation in the notice and give the tenant 3 days to correct it. If the tenant cures the violation within the 3-day window, the notice is void and the tenancy continues. If they don't, the landlord can proceed with filing for eviction. For serious violations, including criminal activity on the premises, drug-related offenses, or conduct that creates an immediate threat to health or safety, Utah allows the landlord to issue a 3-day unconditional quit notice with no opportunity to cure. This means the tenant must vacate within 3 days, regardless of whether the problem could be corrected. Utah also has a specific provision for nuisance. If a tenant engages in conduct that constitutes a nuisance, meaning activity that substantially interferes with other tenants' right to quiet enjoyment, or that creates health or safety hazards, the landlord can issue a 3-day notice to vacate. Here's one thing that makes Utah particularly efficient for landlords. The state allows for expedited eviction proceedings in certain circumstances. Under the unlawful detainer statute, once the landlord files the complaint and the tenant is served, the court can schedule a hearing relatively quickly. And if the tenant fails to respond, the landlord can obtain a default judgment, further speeding up the process. Utah also has what's known as an order of restitution, which is essentially the court order that authorizes the sheriff to physically remove the tenant if they don't vacate voluntarily after the court rules in the landlord's favor. The process from filing to physical removal can be completed in a matter of weeks in straightforward cases, which is considerably faster than many other states. On the tenant side, Utah provides several grounds for early termination. If the landlord fails to maintain the property under the Fit Premises Act, as we discussed in our Utah habitability video, the tenant can terminate after providing proper notice and allowing the landlord time to make repairs. Specifically, for emergency conditions, the landlord gets 3 days, and for non-emergency conditions, the landlord gets 10 days. If the repair isn't made within the required window, the tenant can terminate. Tenants who are victims of domestic violence or dating violence can terminate their lease early under Utah Code Section 57-22-5.1. The tenant must provide written notice along with documentation, such as a protective order, police report, or a statement from a qualified third party like a domestic violence service provider. The termination takes effect within 30 days of the notice. and the landlord cannot charge an early termination penalty. Active duty military members are protected by the Federal Service Members Civil Relief Act, with the standard 30-day notice following deployment or permanent change of station orders. Utah also allows tenants who are 62 years of age or older to terminate a lease early if they are relocating to a care facility, senior housing, or to live with a family member due to health needs. The tenant must provide 60 days notice and documentation supporting the reason. Utah strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove belongings, or take any action to force a tenant out without going through the court process. Violations can result in civil liability for damages to the tenant. One practical consideration for Utah landlords: the state's rapid population growth, particularly along the Wasatch Front in cities like Salt Lake City, Provo, and Ogden, has brought increased attention to landlord-tenant disputes. Courts are seeing higher volumes of eviction filings, and while the process is still relatively efficient compared to many states, landlords should be prepared for potential delays during busy periods. Utah's approach to security deposit return is also tied to the termination process. Landlords must return the security deposit or provide an itemized statement of deductions within 30 days of the tenant vacating the property. If the landlord fails to comply, they may lose the right to claim any deductions and could owe the tenant additional damages. For the complete guide to Utah lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord-tenant law series.